This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Today's guest is Mike Slinn. He's an active software industry technologist and executive with 45 years of experience. He has written 3 books on distributed computing and has taught in university, community college, and commercially. For more than 20 years, Mr. Slinn has provided expert testimony under oath at trial, for hearings, and for depositions. The scope of his engagements include opining and providing declarations regarding hardware and software patents, commercial disputes, and trade secret litigation matters. I'm Michelle Loux, your host of today's show, and I want to welcome Mike Slinn to our podcast. Hi, Mike.
Hey there. It's a pleasure to be here. Thanks for such a great introduction.
You have a very fascinating career, and what I would like to dive in and talk about with you is the basis of this particular show is, what is it that you wish you knew the first time you were an expert witness?
I've had a chance to think about that, and it's been an illuminating experience for me to go back and try to figure out an answer to that. And I must say, it's been very helpful. So thank you for asking me the question. I've had a chance to digest that. And here's what I've learned since you asked me the question. In a nutshell, I wish I knew how client management as a computer consultant differs from client management as an expert witness. When I started as an expert witness, my experience as a computer consultant had been designing and implementing software products, automating business processes, evaluating the work of other technologists, coaching startup founders, and doing technical due diligence for investors. I've worked with, at that point, technical people and their colleagues all over the US and Canada. Now, it's interesting that as an expert, the areas of law that I've had an opportunity to opine on don't have an exact match with the work I did as an expert. There's a lot of overlap, obviously, but it's not a one-to-one. And I thought that was surprising. It's just an irrelevant fact that doesn't really answer your question.
Well, you did talk about some different types of lawyers. Can you explain what that means?
Sure. The Yale Law School has a publication that came out in April 2017, and its title is Law Firm Practice Area Summary. And I count 47 types of lawyers in that document. I've had a chance to work as an expert with 4 of those types: general corporate, litigation, prosecution, and general litigation. Now, I've also been approached by white-collar crime lawyers for 2 cases. And while I wasn't selected as an expert for either of those, I found those really interesting. One of the lawyers that I spoke with described his client as radioactive. And I must admit that was very, very interesting to me. You can read about this person in the news right now these days, but obviously I'm not going to mention that person's name. But I am following that case because I thought, gee, how interesting that would be. Now, as a software entrepreneur, I've also worked with 3 additional types of lawyers: mergers and acquisitions, security and data protection, and licensing and technology transactions. And then as a semi-professional musician, I have been looking at how could I get mixed up with entertainment law, because I find that interesting as well, but that opportunity has yet to arise. I should mention that as an expert witness, many expert witnesses, such as myself, I don't have a formal education in law. So it's probably not surprising that I found portions of this Yale publication to be misleading. Now, I don't mean to say that the publication is incorrect. Instead, I think that it's really a question of false cognates, that is, familiar sounding words that I ascribe meaning to that a trained person in the area of law would have a different understanding of those words. So, for example, The description of litigation lawyers reads, and I'm going to read it here, this practice divides into patent, copyright, trademark, and trade secrets. This is a very adversarial practice. The stakes are high, and for technology companies, this can be bet the company litigation. Research involves not only legal issues, but also factual issues, such as the scope of the market, competitors, and competing technologies and products. These actions are generally not very document intensive. This practice is good for people who are interested in learning about new technologies, products, businesses, and markets. These attorneys work with experts often. People who dislike IP litigation generally don't like the adversarial nature of the practice or not interested in technology. So I agree with most of that description. For example, the adversarial nature of the work. Now, I quite enjoy that aspect, but that's definitely not the case for most technical people. I think that the documents referred to in the description actually refers to the legal documents filed in the case. And now maybe the number of filed documents per case for this type of lawyer isn't a high number. Some of these documents are monsters. So for example, the principal challenge that I had in one case that I worked on as an expert was having to go through 4 long patents. Together, they were about 1,000 pages. And they were deliberately worded to allude to anything and everything while saying very little. Reading these documents was really hard to do. In fact, the only way I could get through this stuff was to stand up for several days and read them aloud and write notes after the end of each paragraph. This was, for me, pure torture. But I felt it was important because I knew that I was going to be asked in deposition if I had read these documents. And the only possible way I could be an expert on this case and provide any value was to say, yes, every word. So I did that. And that was expensive. The client paid for a lot of my time to do that. I was asked that question, and I did give the answer that I needed to give. My testimony and my report was part of what went towards invalidating both those patents into inter-parties reviews. So just to say it's not document intensive, well, it kind of depends what you mean by document. Maybe an attorney has a different understanding of that term than I as a layperson would have. So as a side note, Malcolm Gladwell gave a nice keynote presentation with Adam Grant, also in 2017, at the Wharton People Analytics Conference. It's on a similar topic. It's about an hour long. And if that interests you, it's on YouTube.
Oh, perfect. Yeah, we'll have to tag that and put it into our podcast. Now, really quick. So this 1,000-page document, I mean, would you say that's normal? I mean, do you get a lot of those, or is that particularly for this one case?
This patent troll for this case had, this is how they do it. They have kind of a boilerplate and they spew out these documents in some kind of a factory process. And it's part of their strategy to just make your mind turn to jelly. It's really hard to maintain focus. And so anybody who isn't exceptionally determined isn't going to make it through the document. It's not normal. It's just one strategy that this company employs.
Well, little do they know that Mike Slinn was on the other side. So let's talk about then your first case. If you could share some experience and stories about that with me.
I'd be delighted. Thank you. Well, my first case came to me unexpectedly. The client was a venture capital firm, also known as a VC firm, and they had a big law firm that was working with them. So that lawyer engaged me with a well-written and succinct engagement letter. And the client, which was the VC firm, was concerned that a large software contractor had done a poor job developing software for one of their startup companies. the VCs were apparently considering litigation, and they wanted to know my opinion of the software quality. So before this time, which was 20 years ago, I didn't have a good understanding of what an expert witness was or what they did. I had previously acted as a computer consultant for about 25 years, and I was familiar with the technology, but my weakness was my lack of experience managing this type of assignment. I did not know about different types of lawyers, and so I didn't know how to interface most effectively with the lawyer who engaged me. Now, he was actually outside counsel, and he was an investment management lawyer, not a litigator. And had I understood what that meant, in fact, I didn't know that fact at that time, but had I known it and understood what that meant, I'd like to think I would have approached things a little bit differently. A mentor would have been really helpful to me in that regard. In fact, if you're getting started as an expert witness, having a mentor is an incredible asset. Later on, I did find such a mentor, and I was a protege. And since then, the tables have turned. I've mentored others. It's kind of a guild approach, I think. Anyway, this was the first time I had ever been involved in a three-way engagement. And the three parties were the VC firm, their law firm, and myself. And there was actually a fourth party, which was the startup, but they weren't involved beyond answering questions that I would pose or providing me the software to look at. And there's potentially a fifth party, which was the software contractor. Had we gotten into litigation, this relationship might have become something I would have had to deal with. But in fact, in this case, that never happened. So at the time, I lacked the experience to know that my assignment would have had a better outcome if I contacted the VC firm directly and spoke with them. Now, there are rules about how you can do this, because this is an expert is meant to be an independent third party. And so this has to be an arm's length relationship. To have the attorney would set that up. The attorney would describe the rules of engagement, and to have notes, a transcribed meeting would be very helpful, because you could get hammered in deposition if this went to trial and things weren't done just right. This is also illegal in some countries. Now, what I'm talking to you is a US case, and so we're going by US rules. I have in other cases directly interfaced with the client, and that was very beneficial. The client in one case I'm thinking of had lots of advice for me on how to proceed. I mean, they meant well. First of all, they shouldn't be saying that. And second of all, the advice was off base the whole time, because they didn't really know how an expert should be approaching things. So they meant well, but they were damaging their own case by offering that advice. I documented that because, that's the thing to do, right? So I approached this task as many consulting engineers would. I examined the software, I wrote a report, and I worked through several versions of the report with the lawyer. Again, this is not allowed in many countries, but the purpose of working through versions is to make sure that it's understood by a layperson. So the lawyer I was working with, who wasn't a technologist, would say, so I read this paragraph here, Mike, and here's what it means to me. Is that what you meant? I say, no. Oh, so can you rephrase that? Well, I could say it this way. So what I just understood was this. Is that what you meant? No, not exactly, et cetera, et cetera. So that was the purpose of the multiple versions. Again, that's not allowed in many parts of the world. Well, I presented my final report as a document. I wasn't given the opportunity to present it verbally, which would have been normal. And normally there should have been a discussion, a verbal discussion, That didn't happen either. What happened instead was, boom, the VCs brought down the hammer and decided they were going to shut down the company, shut down their investment. Now, they had put in about $3 million in today's money into this company, and they just decided to flush it. I was shocked. All those people, I thought, surely they're going to lose their jobs. Somehow the software startup survived that trauma and continues on today. I'd like to think that had I known how to handle the matter better, there would have been a different outcome. So my engagement did not, in my opinion, provide long-term value to the client. They never went to trial. I don't know if the contractor ever knew that they were in the crosshairs of a potential litigation. But for there to be long-term value, you'd have to expand the scope of the engagement. And the question of why did this happen and how can we prevent it and how could we improve was never asked. As a subject matter expert, I could easily have provided that information, but that would have required a great deal more client management skill, which I didn't have at that point.
So I want to just ask you there really quick, because you do mention international cases and you were brought forth in Paris, France. And let me double check, get this correct here, on the International Court of Arbitration of the International Chamber of Commerce in Paris, France. So if you could just share with me, like, how this is later on in your career, and I understand, but was a wide eye-opening moment for you where you were just not ready for the different courts, or had you been kind of mentally prepared at that time through your mentors of how to prep for an international case in Paris or Canada versus US at that point later on in your career?
So some of the cases I worked on, I have had the absolute privilege of working with probably some of the best lawyers in the world. Without naming any names, they went to great lengths to educate me on the situation, the constraints I had, the opportunities I had, what was expected as a minimum, what was possible. And that probably was, more than anything, the best education that I've had. So in this particular case, these attorneys, they were outstanding, and they had a quarterback, the guy who kind of was calling the shots at this law firm, who was, one of, he's got to be one of the top guys around, and he wasn't shy about sharing his experience and his advice. So I learned a tremendous amount from these people. This was a tribunal of 5 judges who would sit, that I had to present in front of, and I was the lead of 7 experts. So our side had 7 experts, and there was 1 expert, myself, who would speak for the combined opinion of all of us. And at the end of the case, just at the very end, the other side's expert, there was only 1, and myself, because I was the lead, were brought before the tribunal of 5, and they fired questions at us. And we had an opportunity to respond free form. We would start by letting each of the other speak, and then sometimes we kind of get into the interrupting and the discussion. And this is what they actually wanted. They want to give us the real truth, and we're just going to grill you until we believe something, right? That doesn't happen in the United States. At least I haven't seen it. I don't believe that it does. You got to be fast on your feet and really confident in your facts to be able to say stuff. And the other expert was overconfident. He was confident to the point of being cocky. And he said some really stupid things. And I capitalized on that. It was, it's like, thank you. It was a unique opportunity. So I think being a musician and being comfortable performing to an audience, which is, I've been doing this for 50 years now as a musician, stood me in good stead, because to me, I've got another audience and I've got my material. I've practiced it. I know it. I mean, we're up until 2 a.m. Going over the material, and our attorneys, like on my side, they had their mini tribunal and they tried to give me the gears, and I failed a lot in front of them. But that's okay, because they would coach me. So when the real thing came, it was actually a lot easier than what they had put me through. They deliberately practiced, and that's the way to do it.
Absolutely.
Nothing succeeds like excess.
Yes. Well, I was going to say, now, is French your first language?
I was born to a French mother and an English father. Everything in Paris was done in English. That's the international language.
Okay.
So I never heard any French, but je peux parler français. C'est possible.
I love it. I took French in college and I wish I kept up with it, but s'il vous plaît. That's all I thought I remembered. But I was curious about that, because I didn't know if you would have to have an interpreter, like if you did a German case, for instance, and if you didn't speak German, do you have an English, translator, and how that works? And then does it lost in translation? And are you as effective as an expert witness? So I did wonder about that. So thank you.
Yeah, if it's in front of the ICC, it'll be done in English. And actually, one of the companies was German and the other one was French. So it was kind of like World War III in that sense. But no, that was never an issue.
Okay, interesting. Well, I want to go back to the first case that you talked about, and you explained to me, like, if you had just known a few things and done it a little bit differently, what do you think you could have applied now that you could have done as an expert back then?
Right. Okay. So I've learned that sometimes asking the open-ended questions at opportune times can be of significant value. If it's done in the right way, asking a question can be non-threatening and could lead to good possibilities opening up. And conversely, directly answering a question, which is appropriate in deposition, which is appropriate in court, just sticking to the minimum answer and directly answering, that's what you have to do there. But if you are not, if litigation hasn't been decided upon and you're trying to understand the facts of the case and the context around the case. So that's two things that I didn't quite know then. The facts of the case as opposed to the context. Context can be more important, or as important, let's say, as the facts, because they color what the facts mean and the import of that. If you are just sticking to the facts as presented to you by the attorney that engaged you, you're set up. Now, what if, just imagine the possibility that maybe the questions that are being put in front of you and the evidence put in front of you is there to lead you to a conclusion. And if you don't try to find out all of the context and all of the facts, that you're just a pawn. It would be more appropriate to really question, how did this happen? Where, who, and actually meet the people as you can and ask for extra documents and really kind of push on that. And then something else that I've learned is, yes, you always, within a report, list, these are the things that I relied upon for my opinion, but to also go to say, these are the other documents that I requested that I was denied. And these are the people I was asked to talk to, and they were denied. When I tell the lawyer I'm working with that this is going in my report, it's amazing how things open up because, they realize, they understand the game very well. So not to be a tool means that you're not naive. So a naive, literal expert lacks credibility. And I've been up against, in other cases, where we had, I'm remembering one in particular, a highly credentialed person who was a little bit outside their field, but their credentials were truly impressive. And they were just there to act as a mouthpiece for their client. They didn't have an original thought, and they didn't actually have an opinion because they weren't actually that qualified. And so they're just there parroting whatever they're supposed to do. So it's easy when you see this happening just to present an alternative, to be demonstrably independent, demonstrably transparent. That other guy's credibility was blown to pieces. And that's why I think we, had a big advantage there in deposition right away. My deposition versus his. There's always the back and forth afterwards, the rebuttals, but he kept on, he didn't waver. I mean, every rebuttal he would put forward was just a restatement of his opinion without basis. Whereas I had a reason, and I would explain how I got there and what their line of reasoning was and what the facts I started from, and it was defensible. Nothing he said was defensible. So one way to get the attorney who engaged me to help out in this way would have been to ask for information directly from the client. Could I have a conversation with them, please? I'd like to learn about some of the subtleties and get face-to-face. I think now in retrospect, what was probably going on is that there was a faction within the VC firm that was at war or competing with another faction in the VC firm. And they wanted to assign blame for this problem to an external entity, which was the software contractor, who was generating poor stuff. But you have to ask, how was this allowed to happen? What was the process whereby after a whole lot of time and money goes by, suddenly you got stuff that's no good? Should have known this before. And so blame could have been assigned. I think somebody was trying to escape blame and pin it externally. Instead of going for blame, how about we take this as an opportunity to improve processes, to improve communication? We haven't gone to litigation yet. At this point, it might make sense for me to switch roles and say, suggest to the VC firm, when my report comes out, say, what might be helpful is to resign as a software expert, because you're not going to litigate, and you should engage me as a management consultant, and let's figure out how you as a company can improve and be more profitable and have a winning situation from this, rather than what happened was everybody lost. Now, if that's done in the right way, that'd be allowed internationally, but to just suddenly, keep your expert hat on and try to do that, not allowed anywhere. So there's a certain finesse that would be required in how to suggest it, and there's the right time, and having a relationship of some sort, having at least met the people at the VC firm early on would have allowed that to happen. But never having met them would make that transition very difficult. Because, well, from the attorney's point of view, it doesn't really serve them too much. It doesn't make them any more money. It doesn't, unless they're investors in the firm, but I don't believe they were investors in the VC firm, I mean. So it's important to get some of those relationships begun earlier in order to make a transition. So now I know that if I'm engaged before there's a litigation, that there's many kinds of outcomes. Most of the times that I've been engaged prior to litigation have never gone to litigation. So I would say, at least in my field, if you're engaged before litigation, there's a good chance that you might be able to, if you have the skills, transition to become a management consultant and actually use the information you've gained as an expert to cause some good instead of a lose-lose-lose, which, I mean, why would you want that?
Well, absolutely. Can you share with me your thoughts on what you think the role of an expert witness is?
Well, that really has evolved. When I started, I really didn't know. And then as I spent some time, I realized that I understood what I was told by the attorney that would engage me, and they would tell me what my role was. All of them were very clear, and it was readily understood. And that was to answer questions that are put before me according to the knowledge and experience that I have, starting from facts, applying a reasoning process, and then having opinions. Now, again, opinions are peculiar to the United States, and discussions in front of a tribunal, perhaps, but that's not allowed in Canada. You're not going to, opinions will be thrown away. So answering that question in a US context, what is the role of an expert? You might have several potential answers depending on circumstances. And as always, it's important to state in writing in your report, and every time that somebody asks you this kind of question, the expert should be willing to change their opinion based on evidence as it arises. So you might have an opinion, and then they say, well, what if you just learned that such and such? Oh, well, in that case, I have to reconsider. In context, as I said, can often be very important. Now, before litigation has been launched, this is something that I've come to believe myself. No one has told me this. I haven't read this anywhere, but as I've kind of alluded to before litigation has been launched, I think that the role of an expert is different than after. So the question that was put to me is, do we have a case? Should, if we went to court, would we be able to substantiate our claim that this software is defective? And certainly that is an important, that's the charge you've been given, and you need to directly address that. But to stop there is, without questioning context too much and not being aware of politics and not inquiring about the political context of how did this happen in the first place, is to be naive, and therefore is to be a tool. And so if you're a pawn, the value you provide could be negative overall. Everything you say could be correct, and your reasoning could be correct based on the information provided. But if you don't question the source or the circumstance, you're a pawn. And I prefer to go up against an attorney, go up against an expert witness who doesn't have those questions, because their viewpoint is so limited, their understanding is so limited, that they actually get the facts, the germane facts. They may see the wrong facts and not understand the import of where the real issues lie. So for me, the principal lesson was how I might transition in a pre-litigation case from expert witness to management consultant. And if a management consultant is experienced and perceptive enough, and if support can be identified within the client organization, the management consultant could provide insight and metrics that could drive a client's change management process. So to illustrate how impactful that might have been, here's a few quotes from an article, which is entitled "Consulting is More Than Giving Advice." Harvard Business Review published this article in September 1982. So I'll just read a few short paragraphs here. The consultant also has a professional responsibility to ask whether the problem as posed is what most needs solving. Very often, the client needs help in defining the real issue. Thus, the consultant's first job is to explore the context of the problem. This is what I've been saying. Consultants facilitate learning by including members of the organization in the assignments processes. For example, demonstrating an appropriate technique or recommending a relevant book often accomplishes more than quietly performing a needed analysis. With strong client involvement in the entire process, there'll be many opportunities to help members identify learning needs. Often, a consultant can suggest or help design opportunities for learning about work planning methods, task force assignments, goal setting processes, and so on. Though the effective professional is concerned with executive learning throughout the engagement, it may not be wise to cite this as an explicit goal. Too much talk about client learning comes across as presumptuous, and it is. Learning during processes is a two-way street. In every engagement, consultants should learn how to be more effective in designing and conducting projects. Moreover, the professional's willingness to learn can be contagious. In the best relationships, each party explores the experience with the other in order to learn more from it. Increasingly, the best management consultants define their objective as not just recommending solutions, but helping institutionalize more effective management processes. That's what I've learned.
And you know, what's interesting about all this is that it does seem very daunting, but once you get to you swim through the thick of it, it is very beneficial, right? Like, I mean, that is about the evolution of an expert witness almost, and how to be the right consultant hired for the job and what you're bringing to the table to your clients. You have written many blog articles on your own page, and we've actually republished a few of those on our website as well. So if anyone has an opportunity, definitely check that out under our blog section. I wanted to just shift to something kind of fun. You talk about being a musician. Tell me, what type of instruments do you play? And do you play locally on stage in front of folks too?
I played on television. I played in front of a few hundred people, and kind of still new to Montreal, having moved here from California not so long ago. I've been playing guitar 50 years, bass and various percussion 40 years. I play saxophone, I sing. I'm currently learning to play harp, which is really hard, but fun. And I blog about the technology that I'm using for recording and streaming on my website, which is mslinn.com. And I also blog about my experience as an expert witness there. You'll see the music videos that I'm publishing on Facebook at facebook.com/mslinnmusic, all one word, no punctuation.
You are a true Renaissance man. Thank you so much for being on our show, Mike. And if anyone would like to engage Mike, definitely call Roundtable Group and check him out on his website as well. So thank you for joining us today.
Oh, my pleasure. Thanks, Michelle.
Thank you for listening to our podcast, Discussions at Roundtable. Our show notes are available on our website, roundtablegroup.com. Subscribe today on Apple Podcasts or your favorite listening apps.